My apologies for my delay to the one case I have. Six Trails versus Casey, is it Adkins?
Good afternoon, Your Honor. Cheryl Luckoff on behalf of the plaintiff.
Good afternoon, Your Honor. My name is Leon Boykins, and I'm a student attorney with the Michigan Civil Criminal Litigation Clinic, requesting permission to appear on behalf of Ms. Casey Atkins under Michigan Court Rule 8.120.
Permission to practice is granted.
Thank you.
All right. What are we doing?
Your Honor,
well, good.
it's their motion, so I will let them argue it. I will restrain myself at this moment from any argument.
Okay, go ahead. Go ahead with your motion, counsel.
Okay, so today we are here to argue the merits of Atkins' motion to set aside the default judgment that was entered against her. We believe that she has good cause, as the last appointment was missed because Ms. Atkins, as a single mother, had to take care of her sick daughter on the day of the hearing. And during the hearing, she was in contact with the court clerk, trying to alert her of her situation, and has since tried to reschedule the hearing, as her defense has no.
He was in contact with the court clerk. How?
Email and by phone.
Okay, go ahead.
Yeah, and additionally, lastly, we think that she has a meritorious defense, as this past January, she was without heat for 3 weeks, in which building management instructed her to try to fix the problem herself by consulting YouTube and to also heat our apartment using her oven. So as of right now, we are trying to reinstate the case so that we can come to a fair agreement between both sides.
Is
Your
that
Honor.
when you're saying she withheld rent because of that?
No, we are saying, yes, we are saying that.
Okay. Ms. Luckoff.
Your Honor, first and foremost, I have a motion filed by the defendant, which nowhere states anything about heat. Okay, so this is not an issue before the court based on the motion filed. Number two, the tenant was given a credit for any heat issues. Number three, what was presented to the court actually was that the defendant had filed for rental assistance, that she missed her court date or whatever the reason, and we can even stipulate possibly that there's good cause. But the meritorious defense that was presented to the court was that there was rental assistance pending. This initial hearing was on February 9th. And even if she did have pending rental assistance, which I don't have any documentation of, but she indicates she provided it to the court, the month is up. So if the court is inclined to set aside a default, I would ask to enter a judgment today, because today shows $4,178. But I don't believe she meets the meritorious defense. They're now telling us about heat, which again was not part of the motion and was previously addressed with the tenant. And I would submit she's clearly, she moved in October, she paid 2 months rent, and then she hasn't paid rent since. So the last rental payment received was on December 2nd. And I'm just looking here to see when this credit was provided. It was provided after she brought it up to the landlord, actually in February. But at this juncture, Your Honor, I'm asking for the motion to be denied. And a writ was filed on this. So we'd ask to go forward with the writ.
Why in her motion, counsel, doesn't it say anything about heat?
We just believe she didn't understand the correct legal standard, and the motion, as you'll see, was actually just an email from her to the court. And so now we are just trying to, gather all the correct facts and argue the case properly.
Well, it doesn't work that way, respectfully, Your Honor. I mean, this was what was presented as a motion to the court. And if there was a heat issue, certainly that would have been foremost on her mind when she was filing this motion. This to me is a stalling tactic. And again, rent not being paid since December. Was any rent put into escrow, Your Honor?
Well, that's what I was just looking. You have anything in escrow?
No.
No, I don't even have. So I'm not even sure how this got before me. There's nothing in escrow. She didn't even post 1 month's rent to stay anything with the court. She doesn't say anything about heat. She also, in her email to the court, it's a bit unclear. She requested a Zoom hearing was approved due to her daughter being extremely ill and taking her to the doctor. I was communicating with the clerk through email and was on hold for over an hour. I was taking my daughter to the doctor and she had to have an x-ray. My phone died. And then she said requesting another hearing so it may be heard. And I'm attaching a copy of my doctor's note, which I'm not even clear that I have that.
I did not receive a doctor's note.
Yeah, I don't even have this. I don't want to say it's not here. I'll look through every piece of paper, but I don't even have a doctor's note. She said she was attaching a doctor's note. I don't even have a doctor's note that she says is attached via her email. As I indicated in that, she doesn't say anything about the heat. She doesn't say anything about her withholding rent for some other reason. She doesn't say anything. And she didn't post 1 month's rent to the court rule to stay the proceedings. I'm not even sure why she wasn't there because I don't even have a note, which I would normally have from the clerk's office, that she contacted the clerk's office. She also hasn't attached, she says by email. I don't have any emails from her to our clerk's office or to the court.
Your Honor, if I may, through my communications with Ms. Atkins, she has told me that she will be able to provide documentation of why she wasn't there via doctor's note and.
Yeah, but the hearing's today.
Understandable. I mean, she's also present with us on Zoom today and can maybe also speak to why she was unable to provide the doctor's note up until this point. And it was I was under the impression that she didn't go into the meritorious defense because she was dealing with her family in the hospital and was just trying to reschedule the hearing.
Well, she's asking, the hearing couldn't have been a reschedule because the hearing was on the 16th. The document that she sent to the court, the only document I have is the 23rd, so almost a week later.
Okay, and from my understanding, the health problems with her daughter unfortunately are reoccurring, and there have been multiple appointments that have required her attention.
I'm not doubting any of that. I'm just saying that I get something on the 23rd saying that she was in the taking care of her daughter at the doctor's office, going to provide documentation regarding that. I don't have that documentation. I'm now, that was on February 23rd, and I'm now 2 weeks post that. I don't have anything. There was not a month's rent posted into escrow to stay any proceedings. There's no mention in this, even a week after the fact, about heat or whatever other type of meritorious defense you're bringing up. I have nothing. And quite frankly, I don't even necessarily have good cause for failure to appear because I don't have anything that says why she wouldn't have been available February 16th to appear before the court. So without anything else that had been provided, the motion to set aside the default and or the stated proceedings is denied.
Thank you, Your Honor.
Your Honor.
Thank you.
Have a good weekend.
Okay, everybody do the same. Thank you.
Thank you.
This is gonna have to be processed. I'll sign off. So have the people in here seen the video? What time, what block is this? Really? Why is she smiling? Huh? I don't know. People are usually happy to come see me. I don't know why she's smiling. Alan, watch her. She's probably starting something. I'm just saying. Okay, we can go off. I'm in recess. Now I can talk about it.